Okay, the last bill is House Bill 2382. This has three different parts to this bill. This deals with amendment of declarations. And basically, what this says is that after the developer is no longer in control of your association, the declaration can be amended by the association or an owner of property that is subject to the declaration by an affirmative vote or written consent of the number of eligible voters as prescribed in the declaration. So I think kind of the unique part of this little first part is, okay, first it's after the developer's gone, number one. Number two, either the association's board can propose the amendment or an owner can propose the amendment. Typically, we see associations proposing the amendments, not owners, but this kind of opens the door for owners to be able to do that. And then we still need to get the requisite vote of the membership as is required by your CC&Rs. And so that's the final part of the law. So something to think about. The next part is really confusing. For the life of me, I cannot understand why the legislature put this in here, but it's confusing. The main point is that if your association is trying to pass an amendment that applies to fewer than all the lots, there's going to be a higher requirement to amend than what your CC&Rs requires. So basically it says an amendment to the declaration can apply to fewer than all of the lots or less than all of the property that is bound by the declaration, and the amendment is deemed to conform to the general design and plan of the community if both these things apply. The first part is we'd have to receive the number of consents to amend the declaration pursuant to the amendment section in your CC&Rs. And then second, you're going to have to get 100% of all the owners of the lots or property to which the amendment applies. So if you're trying to tailor an amendment so that it only applies to a certain category of owners in your association, you're going to have to get, let's say you have 75% requirement to amend your documents, you got to get the 75%, and then guess what? You got to get 100% of the 10 owners that are going to be specifically affected by this amendment, which we all know will never happen. So,
what would be an example of something that would apply just to some of the owners?
A lot of associations have mixed use in an association, or maybe they have where they have some provisions in the documents that only apply to townhomes. Like I can think of a good example, like some of the points. You have single-family homes, you have court homes, you have single-family attached, detached. Let's say you just want to pass an amendment that just deals with one of those categories, and it deals with the general design and plan of the community. So maybe it could be something along the lines of, the court home owners have wrought iron fences. Nobody else in the association has a wrought iron fence. We're going to change the maintenance responsibility of those wrought iron fences to the homeowners that have wrought iron fences. The association's no longer going to pay for that. That's something where you're going to need to get the requisite approval of your CC&Rs, so let's say it's 75%, and then you're going to need to get 100% approval of all those wrought iron owners. So it's going to be impossible, let's just be real. So just so you know, this does change the law. This provision does change what the current law is, and it now reflects what common law has always said. Common law would be like case law, so we had kind of a fighting with this particular portion in that, we had a statute that said one thing and then we had case law that was saying something else, so there was an inherent conflict. Now they've made it very clear common law prevails here, and we can't pass these amendments that pertain to only a specific group of owners in your association without having 100% of their approval. The next thing is amendments must be recorded within 30 days after the adoption of the amendment. So if you're doing an amendment procedure in your association, you must, once you get that final vote that you need to get to 75% or whatever your requisite is, you have 30 days, rush, to get that recorded. Otherwise it's invalid. So just keep that in mind. Typically you're going to be working with an attorney if you're doing any amendment to your CC&Rs. And they will be telling you there'll be red flags, there's going to be beeping. They're gonna be chasing you down to get your signature on the amendment and to get that recorded within the 30 days. Otherwise, all that hard work you did to get the amendment passed is gonna go down the drain. And then last but not least, for some of you older associations where maybe you have an older set of documents for your association, if you have what we call a periodic renewal clause in your documents, and let me give an example. Maybe your documents say that your CC&Rs can only be amended in the 90 days prior to a renewal period. So let's say that your association was formed in 1970, and they say that the CC&Rs exist for 20 years, and they can't be amended at any time in the 20 years. If you have this provision, I feel very sorry for you. And then after the 20-year period, then every 5 years, they get automatically renewed, but then the only time you can do an amendment is within the 90 days prior to the 5-year renewal. Okay, I mean, it's like horrible. It's like we can't even figure out what's the date that we start with, right? Typically, it would be the date that the original CC&Rs were recorded. Well, this is a good thing. Our legislature said no more. Any of these associations that have one of these periodical renewals, effective immediately, they can, if they get the votes, the amendment is effective immediately. You don't have to wait the 5 years. You don't have to do it in the 90-day period. So for some of the older associations that may have that in there, that's really good news for them.